So, Erev Tov from Jerusalem, Shalom, wherever you are. And I was delighted to hear that in addition to North America, we have participants from other countries in Europe, and I saw Israeli participants. We are going to be addressing an important issue today. Not that other issues we have covered in our webinars are not, but this is a very delicate, complex, and important issue that the lack of awareness and the lack of reaction to it are rather surprising and tell a lot about the level of unawareness of Jewish leadership outside of Israel to some of the issues that come out of Israel and impact your life, your dignity, your rights, and you are not even aware of it. But before I do that, just a word about our co-sponsors. As always, we are proud and happy to have Ruach Chidush, Rabbis and Cantors for Religious Freedom in Israel, and J-Plan, the Jewish Pluralism Legal Action Network, and the American Association of Jewish Lawyers and Jurists join us in sponsoring these webinar series, in which we sort of alternate between issues that are of particular interest to the general community, issues that are of interest to rabbis and people who focus on halakha and tradition, and today issues that are of interest to lawyers. But as I indicated, really just beyond lawyers. One more thing, we have lined up a number of webinars in the coming weeks. You don't need to take a note, but I will just say that on April 5th, in 2 weeks, I will be covering the question of, it's been a year since the elections in Israel and since the formation of the new government. And the question is, where do we stand a year later on issues of pluralism and religion and state? And I'll try and put some order and update you on what happened during the year. Much of what I will be covering, I doubt that you are aware of or informed of, but I think it'll be of interest to all of you and others who will hopefully join us. Then on April 25th, we will have the legal director of the Association for Civil Rights in Israel, Dan Yakir, share with you an outline of how LGBTQ issues have been unfolding in Israel in terms of the law, in terms of the criminal law, in terms of status, and both the history and where are we now and where does it seem to be going. And he'll be providing also a perspective from the global handling of LGBTQ rights and status, and especially in North America. And lastly, on June 1st, closer to Shavuot, we'll have Dr. Kobi Shapira of the Ministry of Justice, Jewish Law Wing, share with us fascinating selection of rabbinic and modern sources regarding who is a Jew. Some of them are really amazing in terms of the out-of-the-box approach that they represent. So bear in mind, you'll be getting the list. And as for the topic at hand today, Ed Freedman, and you could read his bio in the invitation, and I hope that you either have or will take the opportunity to look at some of the articles that he wrote about connected issues, related issues, mostly with regard to family law, divorce, and in addition to personal status and family law, he has become one of the best known and most appreciated experts on issues of the Hague Convention regarding kidnapping of children. We have known each other for many years. He's a friend of Chidush and a supporter of Chidush. And an interesting sort of connected angle that we mentioned is that for 14 years he represented the Israeli bar at the Knesset legislative deliberations. And today he will share with you an outline of something that, as I mentioned before, impacts on the lives, on the dignity, on the rights, on the freedom of quite a number of diaspora Jews who find themselves traveling to Israel and being detained here because the rabbinic courts claim, and the Knesset has upheld their claim, to have jurisdiction over all Jews when it comes to matters of divorce, but possibly beyond that. And we'll hear now from Ed, who'll describe what the issue is, why is it so, how far does it go, and what's connected with it in terms of Israeli Rabbinic Court's jurisdiction that spans throughout the Jewish world. So Ed, the stage is yours.
Thank you, Uri, for inviting me to this forum. I see a couple of familiar names, although I don't see their faces on the screen, but it seems like a group of people that I would be comfortable meeting face to face. Unfortunately, we're limited to Zoom. Given the approaching holiday of Pesach, I would like to start my presentation by asking the question, why is the Israeli Beit Din different from all other Batei Din? What makes it unique with regard to the personal status of married couples that is different from any other Beit Din located in the diaspora, whether in the US, the UK, or other countries? The answer starts with the Israeli legislation beginning in 1953, which established the religious rabbinical courts in Israel as the sole forum for divorce regarding Jewish couples. In other words, opposed to Batei Din, let's say the Beit Din of London or the Beit Din of New York, which are private in the sense that they are not authorized by the state to assert jurisdiction over anybody other than those couples who agree and consent to their jurisdiction. In Israel, whether you like it or not, whether you consider yourself a religious Jew, an atheist, or a non-affiliated Jew, the jurisdiction for divorce in this country is solely in the Rabbinical Court. Now, what happens if the parties want to, who are getting divorced, want to also deliberate on the ancillary issues to the divorce? In other words, child custody, division of the family assets, matters of child support, spousal support. We have a unique situation where in Israel, those matters, other than the divorce decree itself, can be deliberated in either the rabbinical court or in the civil courts, family courts in Israel. And jurisdiction in those matters is established by the race to the courthouse. Whoever files first in that particular court establishes jurisdiction. Now, without getting into that whole aspect of this race to the courthouse, the issue of ancillary jurisdiction to the Beit Din is extremely important and relevant when we discuss the international jurisdiction of the Beit Din. Since 2005, the legislature, the Knesset, has expanded the jurisdiction of the Israeli Rabbinical Courts. and has established that couples who have some connection to Israel, and that connection is very broadly defined. It could be that one of the parties is an Israeli citizen, perhaps the plaintiff has lived here for a certain time, the defendant lived here for a certain time, and the courts have expanded this definition to include couples whose connection to Israel is rather tangential. People who have family in Israel but never lived here, who own property in Israel, who maybe have relatives who they come and visit on a regular basis. These instances have expanded the jurisdiction of the Israeli Rabbinical Courts to people who would otherwise have absolutely no basis for litigating their marital issues in the courts in Israel. Now, recently, in 2018, the legislature took this one step further. And as you all, I'm sure, are aware, there is an issue within a halachic issue regarding agunot, the women who are unable to receive a get from their husbands in spite of the fact that their marriage is no longer viable. And by the way, there are agunim, men who are unable to obtain a get because their wife refuses to accept it. The rabbinical courts have dealt with this issue in Israel and abroad in various methods, and they have the ability in Israel to apply all kinds of sanctions to what we call recalcitrant spouses, which again could be the husband or the wife. And these sanctions can include loss of your passport, loss of your driver's license, loss of credit cards, and eventually including being put in jail. And there are some cases where husbands have actually spent years in jail and refused to issue a get to their spouse and preferred to spend the time behind bars. Now, for those who are not quite aware, even if the rabbinical court has determined that the parties must get divorced and has even ordered the husband to hand over the get, as long as it is not done voluntarily, there is no get. Now, of course, when you put somebody behind bars, the question is how voluntary is the agreement to give a get. But nonetheless, Israeli courts have the ability to sanction those who do not follow its mandate to either give the get or on behalf of the wife to accept it. Now, this is all relevant after the Knesset expanded the jurisdiction of the family court, of the rabbinical courts, to include, in order to try to solve the problem of the agunot, it now includes the possibility that a Jewish couple living abroad where there either is no rabbinical court or the rabbinical court does not have, the local rabbinical court does not have the ability to force the husband to give the get to the wife. And that's more or less in 100% of the cases, because no non-Israeli rabbinical court has the power to subpoena or to sanction those who do not comply with its mandates. In such situations, the Israeli Rabbinical Court has jurisdiction for such a wife to ask for their get in the Israeli Rabbinical Court. Now, these are two people who might be living in France or in Canada or any place else in the world, who are not necessarily Israeli citizens, at least the husband is not necessarily an Israeli citizen, whose connection to Israel may be that at one point the wife spent some time here, lived here for a year. It could be that the wife has Israeli citizenship, even though the husband does not. The rabbinical court is permitted now to issue a summons to the husband in the event that he has not cooperated up until that point with whatever local rabbinical court is in their jurisdiction, and require that husband to issue a get. Now, you might ask, well, okay, so they require this husband to issue a get, but he lives in Montreal, so why does that bother him? Well, most of these cases, you're talking about individuals who do have some connection to Israel, whether it's family or they come to visit, or simply are possibly connected by having a summer home here or whatever. And anytime the individual comes to Israel, they are now subject to the sanctions of the Israeli Rabbinical Court. And what does that mean? We have very, very effective sealed borders in this country. So if you're visiting here and the Rabbinical Court has determined that you require to give your wife a get and you have not cooperated, not done so, the Israeli Rabbinical Court can impose their sanctions on you. They can prevent you from traveling out of the country. They can require you to post bonds. They can force you to remain here until you give that get. Now, you may say, well, okay, why would you want to permit somebody not to give the get? Well, let's remember that in cases where a foreign national, a non-Israeli citizen is involved, you're talking about proceedings between the couple in a country where the husband doesn't live, where the connections might be slight, and probably in parallel, there are divorce proceedings going on in their country of origin. So you can have a situation where a divorce proceeding is taking place someplace in New Jersey. The wife files for a get in Israel, claiming that the husband won't cooperate with the local New Jersey Beit Din. The Israeli court issues an order that the husband must comply and give the get to the wife. The husband obviously doesn't do so. He is now subject to sanctions should he come to Israel. Beyond that, we know that the Israeli courts often take on authority that they're not supposed to take on. So that the court, the act that gives the Batei Din the right to adjudicate a divorce proceeding between a non-Israeli and the Jewish wife specifically excludes the right to deal with the ancillary issues. As I mentioned before, if you bring matters of child custody, of division of assets, of child support, if you bring that to the Rabbinical Court before they're filed in the family court, the Rabbinical Court has jurisdiction of those matters as well. Now, according to the international jurisdiction, according to the amendment to the Rabbinical Court Act, those topics are off limits for the Rabbinical Courts. They can only deal with the divorce decree. They cannot issue, for instance, property decisions. However, in spite of the fact that under the statute, which deals with Rabbinical Court jurisdiction of those who are not necessarily Israeli residents or citizens, the Rabbinical Courts have taken this one step further, and in some recent cases have stated that although the act prevents them from dealing with ancillary issues, they find that they do have jurisdiction to do so. So now you have a Jewish couple the husband who's not Israeli, the wife files a petition in the court in Israel, in the Rabbinical Court, asking to issue a get, and by the way, also asks for some other relief, such as division of the property. Perhaps they even have some assets in Israel. Well, as we've seen in some of these decisions, the Rabbinical Court is not shy about expanding its jurisdiction. And it's highly likely that some of these cases, the non-Israeli husband will find himself having to litigate issues, not just of the get, but related issues to marital status, including the division of assets. Of course, these issues have been brought up before the courts in other jurisdictions, particularly in the United States. And there are, as you may know, some jurisdictions, for instance, New York and Colorado, as well as Toronto, where the courts have tried to, under civil statutes, assist women who are agunot by prohibiting a civil divorce decree from taking place if the petitioning husband has refused to remove all blocking stones from the wife to remarry. In other words, not giving her a get. However, the rabbinical courts in Israel have taken it one step further. Recently, it's come to my attention of a case I had where the American Jewish couple were in divorce proceedings in the United States, and they went to the local rabbinical court, which issued a get. Now, that get has absolutely no impact on their status in America as a married couple. Halachically, they could go and remarry, but it would be bigamy under American law. The wife, unknowns to the wife who filed the divorce petition, the husband took that decision of the local rabbinical court, brought it to the Beit Din in Israel, asked that the Beit Din in Israel recognize the get of the Beit Din in the United States. And as a matter of fact, as long as the Beit Din that has issued the get abroad is recognized by the Rabbanut in Israel, they will in fact recognize that get. However, they don't find it necessary to advise the wife that the Israeli Rabbinical Court has now domesticated the decision of a Beit Din in the United States. Now, since, as you recall, the Beit Din in Israel is different from the other Beit Din in the world because it's a state-sanctioned judicial authority, by taking the Beit Din, the get of the Beit Din in the United States to the Beit Din in Israel and having it enforced by the Israeli Beit Din, that woman is now divorced all over the world, because as a state judicial body, the courts of Israel are granted comity, just like any other court would be. So now you have a court with no authority in the United States issuing a get, having their decision recognized by the Israeli court, turning a non-recognized get into an official divorce, changing the status of the parties, and this woman is not even notified. Not only that the petition has been filed, she isn't notified that the divorce was recognized, and she is now divorced. Now, I discussed this with, I can see Uri is even surprised about this one. I discussed this with the clerk of the Rabbinical Court in Tel Aviv, and I asked him how you could possibly justify such a total disregard of basic due process. And you know, the Israeli Rabbinical Courts, in spite of the fact that they determine their decisions based on din Torah, the notions of due process and some of the call them common law legal practice have seeped into the rabbinical courts. And when I explained that anytime you want to enforce a foreign judgment, the rabbinical court requires the other party to be notified. How can it be that recognizing a non-binding get from another country does not even require notification to the other party? And the clerk said, well, that's our practice. And why? Because under the regulations that control for the rabbinical court, indeed, you are required to notify the other party when a proceeding is filed, but there is an exception that the dayanim, the rabbinical judges, may diverge from that requirement and use their discretion. And it seems to be that their discretion has determined that when taking a rabbinical get from a foreign country and domesticating it in Israel, there's no requirement to notify the other party. So now you have a situation where not only do you have a non-Israeli spouse getting divorced in Israel, that spouse is now divorced in America as well. Now, that happens to have been a case brought just these circumstances in New York Supreme Court, which, for those of you who are not New Yorkers, New York Supreme Court is not the high court in New York. It's the trial court, and it's the court with jurisdiction over family matters. And with those same circumstances, the wife came into the Supreme Court in Brooklyn and said, this situation where a non-binding get was issued by a court in Brooklyn has now become a binding a binding judgment of the Israeli court, thereby now making me a divorced woman, even though there was no procedure in this that I participated in to declare me divorced. And the Supreme Court in Brooklyn said, this will not fly in our court. You can't take a non-binding get from a Brooklyn court, which is not recognized by the laws of the state of New York, take it to another jurisdiction, have it domesticated, and turn it into a binding divorce decree. Unfortunately, none of the rabbinical dayanim in Israel are aware of this judgment, and they continue issuing divorce decrees based on non-binding batei din in other countries, which changes the marital status. Now, I'm sure that there are appropriate cases where somebody, perhaps somebody like Uri, would be willing to go to the High Court of Justice on one of these cases and see whether or not the Supreme Court of Israel would be willing to interfere on this practice. But what it does is it means that even without your knowledge, you could be subject to an Israeli divorce decree, changing your status and possibly even dividing property should you own an apartment in Israel or have a bank account here, as many Jews do, without you being aware of it and without you consenting to it.
If I can maybe just stop you for a second,
Sure.
Because already we got questions that show that maybe the issue of jurisdiction is not entirely clear yet.
Okay.
So Mark Henshin, also co-chair of JPLAN, an attorney in Toronto, is asking, how can that be with a wife not agreeing to the jurisdiction of the Rabbinic Court? And on the other hand, we have Deborah, I'm always confused about or not getting your last name. All right.
Paul Rutger.
Yeah, Nachon. So we might as well ask your question. You say she agreed to the divorce, didn't she? Right?
She
So
agreed.
is it not justified for the court to do that?
Okay.
All right, go ahead.
Okay, well, let's separate the religious get from a divorce that's binding under the laws of the jurisdiction that you live in. It may be that I have agreed to a get in the Beit Din of America in New York. That does not make me divorced in New York. It means that if I attempt to remarry in New York, that's bigamy. It also does not resolve any of the issues that are connected to the divorce. It's simply a religious decree that means that under Din Torah, I can remarry. And of course, the Batei Din in Israel don't recognize as completely or in the same, as entirely the same status of a married couple that is not married under Din Torah. However, the Rabbinical Court has accepted that even those Jews who marry civilly are in their jurisdiction. In other words, if an Israeli couple goes out, as many of them do, and gets married in Cyprus and comes back to Israel, although the marriage is not legitimate under Din Torah, the Rabbinical Court will still issue them a get because they recognize that they're recognized as being married in the rest of the world. So the agreement of the wife for a get in New Jersey or in Toronto doesn't mean that she's agreed to jurisdiction of another country over their divorce. Her status in New Jersey is still married. She is not divorced by any means outside of that private Beit Din, which has no authority. So I hope the distinction is clear between what a Beit Din can do in the US or in Canada or in the UK and what a Beit Din in Israel can do, which is entirely different.
Let me maybe sharpen a couple of the points that you made and take it one step beyond. One thing is, since you described what the situation was and what it currently is, I want everybody to be clear on, we are now dealing with a Knesset law that empowers the rabbinic courts to have jurisdiction in these divorce matters over all Jews in the world. There are certain conditions, but they are not taken particularly seriously, as Ed has explained, since no rabbinic court in the world has a compulsory jurisdiction or legal jurisdiction. Therefore, that requirement that they have exhausted the ability to have divorce through a rabbinic court, of course, is met. So you can have a Jewish couple from New Jersey where they've been involved in litigation over divorce for years. The husband comes to Israel to visit his ailing mother. The wife, unbeknownst to him, has submitted a divorce suit to the rabbinic court. Once he enters Israel, and the computerized system indicates that he has entered the country, he is basically detained because more often than not, once such a suit is submitted to the rabbinic court, an injunction is issued, a restraint order is issued that forbids him from leaving the country. And the next communication is done with the individual being in prison, because either he is stuck in the country indefinitely until the divorce proceedings are resolved, and as far as the rabbinic court is concerned, they have patience. It can take months, it can take years, that's okay, so long as you stay in the country. And in some extreme cases, they have issued a detention order against those husbands. It's for, understandably, a justified and important cause to relieve the dilemma, the problem of agunot, but at what cost? So we are not dealing with black or white situation, and the question is, how do you evaluate between these two conflicting interests? One is to ensure that women who wish to be released of a Jewish marriage have some venue that can release them, even though when they married, they did not contemplate that Israel will have jurisdiction over that. And on the other hand, there is no other country in the world that expands the jurisdiction of their religious courts over all members of that religious community. And I'll finish that. Israel itself is in a touchy point here, because Israel fought against the idea that in some countries, the civil courts claim to have jurisdiction over war criminals, and when complaints have been submitted against Israeli officers for committing war crimes, and as you may recall, all of you, most of you may recall, when Israeli generals involved in wars in Israel were traveling to England or to the Scandinavian countries, and there was the real possibility that once they enter that country, they'll be detained. And Israel said, what right do you have to expand your jurisdiction over us? So Israel itself has made such an idea of international jurisdiction over people who have no connection to those countries unacceptable. So how do you deal with the dilemma?
Well, first of all, I don't think you can deal with the dilemma by implementing legislation that so far exceeds what we would call normative jurisdiction over non-residents. Now, every country has, or every state has certain requirements before you can file a divorce. Some of them require at least one of the parties to be a resident for a year. I think Nevada is the record. You only need to be there 6 weeks. But they all require some kind of connection. However, in Israel, almost any connection is good enough. In other words, the definition of being in Israel, which is what the law requires, can mean that you come to visit once a year. And I don't think that a country that respects the basic civil rights and guarantees due process can solve an halachic problem by abusing civil procedures in its courts. I think that for those who feel that a get is necessary in order for them to continue their lives, whether or not they're particularly orthodox is not the issue. There needs to be an halachic solution and not a civil procedure which imposes the laws and the restrictions and the sanctions of one country upon those who never dreamed that they were going to be subject to those laws. You know, in Israel, one of the choice of law regarding what applies to divorce, and the actual law says that the law of the place of the marriage is the law that should apply. And this goes way back because there were lots of cases where people came from gathering of the exiles, and people would be married in Italy or France or England, and then 25, 30 years later moved to Israel. Suddenly the ground rules changed. So the law in Israel says it's the place where you were married. Now comes the law and says, doesn't matter where you were married, doesn't matter where you live. If you're Jewish and we can get our hands on you, you're subject to our law. Now, it does require that you be served, properly served. So the husband who's a foreign resident, if the wife has applied for divorce in Israel under this expanded jurisdiction amendment, he must be served, as opposed to the situation where the rabbinical court simply domesticates a foreign rabbinical court's judgment where they don't get served, which is even worse. So I don't think you can right one wrong by creating more wrongs. I think that the emphasis has to be on a halakhic solution.
Rabbi Bruce Kahn is asking, Israel Bet Din says you're divorced. New York Supreme Court says you're not divorced. How is it resolved?
Well, it isn't. As long as you're in New York, you're not divorced. But the minute you are outside of New York jurisdiction, it's an open question. Whether or not another country will grant comity to what we call a bootstrap decision. You're taking something out of nothing and creating a jurisdiction. If court in England is willing to recognize an Israeli divorce decree that's nothing more than domestication of a New York Rabbinical Court that has no jurisdiction, then we're in big trouble. As far as I know, there hasn't been another state outside of New York where this issue has been presented. But the fact is, the person is in Israel, they're divorced. If they travel to New York, they're still married.
Judge Peter
And not only
Buxbaum.
that, let me just add that if this woman were to ask for permission from the Rabbinical Court in Israel to remarry, you may not be aware, but before you can marry in Israel, you need to be declared that you are available, that you're free to marry. This person who's married under New York law could go to the Rabbinical Court in Israel, ask for what they call tudat ravakut, a confirmation that they are single, and remarry in Israel. So they can be a bigamist in New York and legally married in Israel.
Just Peter Buxbaum, maybe unmute yourself and ask the question, because I'm not sure that I can repeat it properly. Peter?
Anipo.
Yeah, so ask the question.
Well, I was thinking of an analogy to the old quasi in rem jurisdiction we had in the United States.
Mm-hmm.
The debt followed the debtor. And it seemed like the marital debt kind of follows the marital debtor here, even though there's no other real due process involved.
Remember that we're not talking about anybody who's been who has a judgment rendered against them. It's not. We're not talking about enforcing a foreign judgment. We're talking about creating the situation for a get. There's a difference between recognition of a foreign divorce judgment, which the laws of comity would apply in Israel as well, and creating the ability to receive a divorce judgment. So there is any kind of jurisdiction, not quasi in rem, not in no race. There's no jurisdiction over the marital race. There's nothing except the fact that they're both Jewish.
Well, our old theory was that I don't want to get into it too much. It's very technical, and it was hard to understand when I was in law school. So,
okay.
Maybe I should just let's let it go.
Thank you.
Continue offline.
So Alan Washer is asking, who cares in essence? Namely, okay, so for Orthodox couples, obtaining a halachic get is important, but most Jews are not Orthodox. So is it really relevant for the non-Orthodox?
Well, as I said before, many couples, certainly in Israel, who are not Orthodox, still want to have the get in order to before they'll remarry. And I don't know if there's no statistics on it, but those who consider themselves to be traditionalists, and they may be Reform, they may be conservative, they may be non-affiliated, but there are people who believe, maybe even for family reasons, The grandfather would be highly disappointed and wouldn't attend the wedding if you didn't get a get first. And there are a lot of couples like that. So even though many people don't care about having a get or not, those that take that step or attempt to have a get issued are creating a situation where those that would not necessarily be willing to submit to a foreign jurisdiction are forced to do so. And that's a problem for the Israeli jurisprudence.
Well, Richard Flom is responding in part as saying, well, in the case of conservative Jews, no rabbi in the Rabbinical Assembly will remarry that individual if there is no get. So for conservative Jews, that may be more relevant than you think, Alan. But beyond that, I'm sure we are all familiar with the phenomenon of people changing their mindset, changing their religious convictions. And at times, this kind of change of life of one spouse causes a dissolution of the marriage. And here you have one spouse, a secular couple, reform couple, one spouse, the wife, has seen the light. And now she, as Ed has explained, wants to make sure that she has a get, because she may want to remarry whoever, and she doesn't want the children to be under some halachic suspicion of illegitimacy. So again, the question is, the husband has no connection to Israel, does not want to put himself under the jurisdiction of the rabbinic courts, may be willing to cooperate with a wife under mutual terms if they come to an agreement. But since they don't come to an agreement on all matters, she unilaterally goes to Israel, and the poor guy comes to Israel with a congregational trip and finds himself restrained.
Yeah, I also would point out, Uri, that in many cases, before a divorced individual can remarry, sometimes it's the new partner who requests that they have a get before they can remarry. Because if you want to remarry, let's say in Israel, you can't unless you have a get. You will be forced to go abroad to have the marriage. So if you want to remarry an Israeli resident, you would need to produce the get.
Definitely. Now, Jane Sasswine is asking, would Israel recognize a get issued by Reform or conservative or reconstructionist with perhaps a woman on the Beit Din?
Well, regardless of whether there's a woman on the Beit Din, the answer is no. They won't even recognize an Orthodox Beit Din or an Orthodox rabbi who wishes to get unless they are on their selective list. They have their own list, which they will never publish, but they will let you know if the rabbi you got divorced with in Los Angeles, is his get kosher or not? And he may or may not be Orthodox, but not every Orthodox rabbi will be on that list. Now, interestingly, because Israel is not a totally theocratic state, only a semi-theocratic state, the court in Israel, the Supreme Court, has ruled that the population registry where individuals' marital status is listed must act according to the foreign divorce, so that if I were divorced under California law by an authorized California court, and I come to Israel and I do not have a get, my status in the population ministry is divorcee, because they have no choice but to register my legitimate divorce decree from California. However, the Beit Din will never recognize that. So that while you're in Israel, you have dual status. If you walk into the population ministry or any civil governmental agency, you're divorced. But if you go into the Beit Din, you're married, and you can't remarry in Israel unless the Beit Din determines that you're divorced. So you have a bifurcated status within this country. And in some cases, and I've seen this happen, a person registers their divorce in Israel. The woman does not have a get. They can remarry abroad. They're still married in the Beit Din, but they're divorced in the population registry. The remarriage also gets registered in the population registry. Now, this woman is married to two different people in Israel, but is still not divorced under rabbinical law.
Well, the last point that you made, I think it's probably helpful to put it in context. You have a population registry, which is a civil registry. And as Ed explained, the things that are registered there under the accepted norms in, private international law run contrary often to the position of the chief rabbinate in Israel and the rabbinic courts. So how do you deal with this conflict? Well, you deal with it in a typical way, because it's really the religious politicians that could sort of pressure the formulation of the law. And therefore, when the population registry law was enacted, back I think in 1965, it includes a clause that says that the items included in the registry that refer to the personal status, marital status, name of the spouse, and the religious and national identity are not even, what's the Latin term? They are not proof of their contents. So basically, we have indeed a population registry which states that what's written as to whether you are married or not has no necessary probatory power on whether you are really married or not. Interestingly, that is exactly the reason why the Supreme Court could apply a flexible approach to the question of who is a Jew, basically saying that when a recognition or registration of civil marriages overseas, and registration of intermarriages, and registration of Reform or Conservative or Reconstructionist converts, because the court said the issue of halakha, the view of the Rabbinic Court, is irrelevant to what is registered, and because that marriage, that civil marriage, is recognized at the place where it took place, as you mentioned before, this is sufficient to register it regardless of what the view that the Rabbinic Court holds. We have, Alan Warshaw is asking, please remind us this broader treatment by the Israeli court is recent. Are there current legal challenges to these broader treatments, such as what IRAC, the Israel Religious Action Center, is addressing? So maybe mention that the final legislation that made this into a permanent law and not a temporary provision was passed just a couple months ago.
Right. The original amendment was in 2018, and it was what they call a temporary amendment. Now, initially the proposed amendment was to apply to both men and women, but it was finally adopted only to apply to women. And I had a client from Austria who wanted to get a get. He wasn't Orthodox, but he had his reasons. And he was unable to make the application in the rabbinical court here, even though the Viennese Rabbinical Court had no authority to issue a binding divorce decree. So I filed a petition with the Supreme Court of Israel, sitting as the Court of Justice, High Court of Justice, claiming that this amendment to the rabbinical law was discriminatory against men. It only applied to wives. Now, of course, I first had to make the application to the rabbinical courts themselves, the district court and the Supreme Rabbinical Court, and both of them turned me down, stating they agreed with my position, but their hands were tied by the law. Therefore, they subtly referred me to the court that would be able to resolve this issue, being the Supreme Court of Israel, sitting as the High Court of Justice. So I went ahead and filed this petition. Was done last summer, actually. And between the time I filed the petition and the time it was heard, the temporary amendment had expired and the new permanent amendment had not yet gone into effect. So the court said, well, we don't have to deal with this. Doesn't exist. The court threw me out without even a hearing because of this technicality that there was no act at that time that actually implemented this discriminatory amendment. Would it be issued again? What the court would do now, now that the law has become a permanent amendment, I don't know. The Supreme Court of Israel, despite the claims that it's running our lives and interfering with the legislature, is very reluctant to intercede when issues are determined by the rabbinical courts in Israel, or any religious courts for that matter. Could be the Sharia courts, which I've had experience doing the same thing. The Supreme Court doesn't like to get into these messy matters. So I think that there are a lot of things wrong with this amendment, one of them being that it only applies to women and not to men. But as it stands now, that's the law of the state of Israel.
Well, it sort of brings us, a whole circle back to the initial topic as we presented it. This is an example of the mingling of religion and state, of religious law and civil law, which is quite unique to Israel and probably a number of Islamic countries that impose Sharia law on their citizens and has an ambivalent attitude towards civil law. The question that I want to leave you with, not open a new discussion, but leave you with is clearly what you heard from Ed Freedman is this isn't just an abstract theoretical issue. This involves scores of couples now and into the future, where since the makeup of the law now makes it possible only for women to submit such lawsuits, where the husband may find himself against his will, bound to remain in Israel until he says, "Rotze ani," I'm willing to, and signs on the dotted line, without the leadership of the Jewish community, the Jewish federations, the Jewish advocacy organizations that are quick to submit amicus where Jewish rights are being infringed upon in some foreign countries, that are schreien Gewalt when rights are being limited and human dignity is being challenged. None of them has spoken on this issue. None of them has seen fit to safeguard the rights of the members of their communities when the deliberations on the law took place at the Knesset. Have they acted in a responsible manner? Have they exercised their responsibility to the members of their community and protecting their rights and dignity and sovereignty of those countries? Have they all gotten the, muzzled themselves because somehow it involves the rabbinic courts in Israel and the interest of the political powers that be to empower the rabbinic courts beyond their former authority and jurisdiction? I don't know. But this is, as we say, a mashal, a parable. This is an extreme example of the harm that can be done, of the conflicts that can arise from mixing religion and states when you, as diaspora Jewish communities, sort of close your eyes, sit back, and don't feel that you have a stake in these matters. So Ed's presentation, I hope, conveyed the message: you have a stake. Hopefully, probably all the people on this call are not individually, personally affected by it, but the community as a whole is. And this is a question that I think should be borne in mind and possibly acted on in the future. Ed, any parting words?
Chag Pesach Kasher v'Sameach.
Well, let's not, of course, forget that Passover is celebrating freedom, liberty from bondage. And to the extent that we take rabbinic interpretory liberty and see the freedom from bondage as widely defined, certainly the scores of husbands who found themselves held in restraint, and some of them held in prison. And in cases that do not involve necessarily unreasonable interest in carrying out the marital dispute in normal civil courts, whether that is justified or not, or whether the principle of celebrating freedom as a Jewish trait, as a Jewish virtue, should have had the upper hand, I don't know, but by all means, let's celebrate Pesach and herald in freedom, and herald in freedom for those who are now under threat of extinction, threat of war, threat of being relocated as refugees, millions of them. So may freedom reign, and may freedom and justice for all be welcomed as the holiday nears. Thank you so much, Ed. Shalom. And again, a reminder, 2 weeks from now, we'll be doing a sort of a checkup, annual checkup. A year has passed since the elections and the formation of the new government, and we'll be looking at the larger picture of religion and state in Israel and pluralism through the eyes of the new government, and what had transpired during this year, what will be happening in the next term of the Knesset after it finishes the winter break. And then on April 25th, we'll be discussing LGBTQ in Israel, history, current state of affairs, where is it going, and we'll be comparing it to the parallel unfolding of the status of LGBTQ in North America. And lastly, when Shavuot nears, June 1st, we'll have Dr. Kobi Shapira of the Ministry of Justice provide you with an amazing opportunity of study of diverse religious sources, and even within Orthodoxy, diverse religious rulings, extremely diverse, some of them very close to what most of the people, if not all of the people on this call would identify with on who is a Jew. So thank you all, Shalom and Chag Sameach.